The only good idea is to let me and John do our job and mediate this thing right here.
You want to hear the crazy thing? I know it doesn't feel like it, but we're making progress.
Settle! Settle, 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 settle!
I don't want to settle.
All we're trying to say is, put your swords away for a second. Let's finish this and let's move on.
Welcome to Mediator in the Middle. This is your place to peek behind the curtain of what a mediator is really thinking. I'm your host, Abe Melamed, a litigator turned mediator. In this series, I, along with world-renowned mediators, will offer you, the clients, the lawyers, the parties to mediations, tips and tricks on how to be more effective in mediation and ultimately get yourself the best result possible. Thank you for listening. Please enjoy. Welcome back to Mediator in the Middle, a podcast about mediation by mediators for lawyers, for the litigators, their clients, anyone who participates in mediation. I'm your host, Abe Melamed, and I'm really excited today to have a great guest, JJ Johnston. JJ is maybe the only mediator I know who really exclusively focuses on employment, and that has a lot of value to the clients that want someone who has an understanding of the real deep knowledge you need of employment laws and the cases. And he's just an amazing mediator. He's been doing it for a really long time. Before he shifted to mediation full-time, was a litigator for many years, 35 years or so, 20 of which was in employment, the last 20. So someone with a real deep knowledge and experience of the subject matter and also mediation generally.
Thank you for that great introduction. I don't think there was anything you could have added to that, so I appreciate it.
Well, no, I appreciate you taking the time. And we've got a good topic today for our listeners and our viewers. And it's kind of a broad topic, and I think we'll end up starting very broad and narrowing down a little bit. But what is the purpose of mediation? Really, this might have been more properly the very first episode of the podcast, but it's, every single litigator coming into mediation should be thinking about what the purpose, what the goal is of that mediation. And they may have very different needs and very different goals, but just kind of saying, well, this case seems like it's maybe ready to settle, let's just throw a mediation on the books and show up, doesn't seem like the best plan. But being kind of purposeful of thinking about what is the purpose is, I think, a critical step. But tell me what your thoughts are about that. How do you think that litigators should approach choosing their mediator and deciding on the actual value of the mediation to them?
Yeah, well, I think a lot of it depends on where the case is in terms of the litigation process, whether it's pre-litigation as opposed to a case that had just been filed recently, and now the parties want to do an early mediation to kind of see if they can limit risk and costs. And then sometimes, we get them like a couple weeks before trial or a week before trial, kind of a last-ditch effort to get the case resolved and have certainty, and not having to leave the case result in the hands of 12 strangers on the jury. And I think, being commercial mediators, I think the goal in any mediation primarily is to try to get the case settled. And then there's, I think, sub goals to that. I mean, mediation's an opportunity to learn more about the other side's positions and to be able to kind of figure out early on if the case is being mediated early, what to look out for in terms of weaknesses and so forth. And it's also an opportunity, and this is where I think this plays into the need to really do a lot of preparation and provide the mediator with thorough briefing and in a timely way as part of an opportunity to present your side of the case in a strong way to the other side, with the hopes that the other side will see things that you feel are important about the case that should justify the case settling for a certain amount. So
persuading them to adjust to your position, if you will.
Yeah, and I think, I see mediation as kind of a partnership between the mediator and the parties. And I think it was Lee J. Berman who was having a discussion one day about, I think he referred to it as mutual bias. And the idea being that, when the mediator's in one room, that they're kind of biased in favor of that party while they're in that room. And in the sense that, the mediator role is to to help the party formulate arguments to take to the other room. And then, of course, when the mediator goes to the other room, he or she does the same thing. And the idea is with both sides presenting their best cases and arguments as part of the process, that helps facilitate a settlement and bring the parties' expectations into realistic ranges that facilitate getting settlement.
Yeah, and I think, I want to kind of dive in a little bit more to some of those specific things, the specific acts the mediators can do in preparation. And we did have actually a great episode with Lee J. Berman all about front loading the process and, getting as much information in advance. But to kind of focus in a second on the decision to go mediate and what your goal is, I'm curious, what are some of the kind of areas that you see, or some of the objectives that you think that lawyers might be looking for that maybe they haven't articulated? And I'll just give you an example. Sometimes, I find with certain clients, I'm brought in to be the voice of reason with the plaintiff. The lawyers have talked to the plaintiff over and over. They've explained the risks. Obviously, they have to dance around it a little bit because they can't come off to the client as biased against their client. They don't want to drive a wedge. But, sometimes they're saying to me as the mediator, listen, we believe that this is a case that should settle. We believe that it should settle in XYZ range. The client has an unrealistic expectation. Can you have that conversation and see if that can make a difference? Other times it's my client, I've got full client control. My client's completely going to trust what I recommend. I don't need you to play that role at all, but I need you to be the effective tool to get the most money from the other side because I can't negotiate that directly and we're too positional. Sometimes we've tried to have positional discussions and get this resolved, but we're getting into log jams, and I think we need a creative solution. We need a kind of third party creative mind to come in and help us. And I'm sure there's a dozen different things that we can identify, but I'm kind of curious if you have a handful that you think you see maybe more commonly over and over between clients, where maybe the lawyers in the process, it's clear to us as the mediators watching it that that's what that lawyer needed or that's what that client needed. But maybe the lawyers themselves in advance of the mediation aren't really thinking about it that way. They're kind of just like, well, I know there's something about the mediation process that's going to help me get this case resolved. Let's just go mediate. But if they can come into the process being a little more thoughtful about that, it also gives them the chance to tell us as the mediators how we can be most helpful. And I think that would be really interesting to hear from you what some of those things are that you think, if you're a litigator, you've got a case that you think might be ready to tee up for mediation, try to look internally and be thoughtful about what is my objective in this mediation process. And so what might be some of the things that you think you see more often than not are the objectives of the lawyers that they can think about?
Well, I think you did a pretty good job just discussing a minute ago what you've observed in terms of different motivations for parties to enter into mediations. I don't have a lot to add. I know sometimes I mediate cases where I think the party knows a certain decision has to be made about the case and doesn't want blowback from their client. And so they want a mediator to take the hit for them. In other words, they want to be the good guy. They want to look like the good guy. So they'll have the mediator tell them the bad news that, their case is terrible or their defenses are terrible. And then, sort of reluctantly agree with the mediator as the process goes along in the hopes of maintaining, that client, particularly on the defense side where they've got repeat business from clients and they want to maintain those relationships. And yet they know they need to bring their client to a certain decision, and it's just easier to do that to have a third party mediator come in and sort of explain why that needs to happen. I think you're right too about attorneys needing or should be thoughtful about the process in terms of strategically how they're thinking about how they want to handle the mediation and the best way to get the results that they're looking for. And I don't see a lot of that. I think, even though I think it would be in their best interest to look at it that way. But, frankly, a lot of times I just think parties think that they can get a better deal with a mediator than direct back and forth settlement negotiations. And so they schedule a mediation and then they, prepare briefs ahead of time. Sometimes they're timely, sometimes they're not timely, which is another issue we can discuss. And then and they see it, and they kind of just play it by ear to see how the process plays out. I mean, I don't do half-day mediations anymore, so all my mediations are full day. So the parties know that they've got from 10 a.m. until whenever, even after 5 till midnight or beyond, if it takes that long. So they don't feel kind of under the gun to put everything into their brief that maybe they should, or to think a lot about strategy, because I see a lot of strategy changes during the process. I think maybe more on the plaintiff side in that regard, where their strategy kind of evolves as the process moves forward. But on the defense side too, I think if you're looking at terms of case value, I think the majority of mediations, the parties come in with an idea about what they'd like to see happen, and that changes during the process. And I think that's what makes mediation so valuable, because it does facilitate those changes that make it easier to get to a settlement.
Absolutely. I think that's that if we do our jobs right, then on both sides, there's some adjustments. And the one other kind of interesting area, I'm curious if you have the same experience, but there's this conversation about a mediator being evaluative versus facilitative, and somewhere on that spectrum. And I always, when I was a litigator, viewed it more about the style of the mediator. Some of them come in and just yell and scream and a lot of times it's retired judges, but it's the mentality of, here is why you must settle and you are going to lose. I've had a recent experience with several clients, and usually it's repeat clients that I've worked with a handful of times, who said, Abe, I actually really appreciate your neutral third-party view because you're an expert in this subject matter. I want to see if there's something I missed, because I'm a smart lawyer, but I've been in, the tunnel for a long time. Is there anything new? And then it's really rewarding to me when I come in and I point out 1 or 2 or 3 things, and they actually say, I'm going to take note of that and send that to the adjuster right now, because that's an interesting point. And I actually started to incorporate AI into my practice in this way, because and this evolved from the mediation game. I was putting the scenarios into AI to guess the outcomes, but what I found is that if you put very broad facts, so confidentiality wise, you're okay, but the broad facts of a case into AI, and you ask it a question like, imagine you're a mediator, what questions would you want to ask the plaintiff based on this fact pattern? How might you present, what evidence might you present to sway a party? And it'll pump out 10 or 12 questions. And what blew me away is, I think I'm really good at this, but 10 out of the 12 questions I had thought of, but there was always like 1 or 2 angles that I didn't even think of. And it's just because it's AI, it's computing power. And so I've started to incorporate that now into my practice, where it's like part of what I think I can offer to people is giving that neutral, evaluative perspective, not in a beating up kind of way like some mediators. That's just not my style. I know it's not yours, but to just be able to play that role. And so I'm curious if you've had that experience, especially because you really are an expert in employment law. Do you find sometimes that the parties are coming to you, not just in name, like they say, well, yeah, we want you to evaluate or whatever, but that they actually genuinely say, you might have some insight that I didn't even think of. I want to bring you in to consult essentially on this to help me really evaluate this?
Yeah, it's an interesting question. This idea of being evaluative or facilitative, I think it's those discussions about those 2 different styles are a little bit overblown, in the sense that the idea of putting people in one box or the other, or mediators into one box or the other, isn't really realistic. I think most mediators, and me for sure, have a mixture of facilitative and evaluative in our approaches. And I think that's necessary, particularly in employment cases. And I do think that some people choose me because they're aware of my background and my expertise in this area of law. But in terms of how that comes up as part of the process, usually as the mediation progresses, I'll give my sort of opinion as to likely as I see it, in terms of issues that are in dispute, or what might happen in terms of damages and how a jury might feel about certain issues and so forth. But you're right. Sometimes I'll be talking to an attorney on one side or the other, and they'll just say, look, this is what I think how I look at the case. Like, for example, from a plaintiff's perspective, this looks like a great case to me. Tell me where I'm wrong. I mean, tell me, am I missing anything? If they're missing something, I'll tell them, hey, well, maybe you're missing this, assuming this is going to happen, but the other side's got a different viewpoint and evidence that suggests that maybe that's not as clear cut as you think it might be. Sometimes they've got a great case, and I think a mistake some mediators make is they take playing devil's advocate too far to the point where they lose credibility. So in other words, if you're talking to an experienced attorney and they're a defendant, they've got a really great defense that either is going to result in a summary judgment being granted or really good things happening at trial. And you try to play devil's advocate and bring up stuff that, that aren't really legitimate arguments. Then you lose credibility, and then that's one of the worst things that can happen to a mediator is losing credibility, because then you really lose your ability to have any control over the process if that happens. And that comes up as part of the evaluative aspect of the process. And I have to say to a party, like a plaintiff, for example, I think you do have a great case here. I think, you seem to have all these things lined up, but then I might discuss other issues, like let's talk about damages, let's talk about the venue that you're in, let's talk about if your attorney fees are going to get cut back, and focus on that rather than trying to push some argument that is not going to fly to them.
Right. And there's a lot of other values that come from resolution that have nothing to do per se with the merits. There's resolution, there's on the plaintiff side, it's being able to resolve it and move on. And the defense side, it might be the lack of business disruption or ending the business disruption, ending the reputational harm. And so there's always something for us to work on. I guess that's what it is.
Yeah, there's always a topic that that can be used as part of your persuasion process. It kind of reminds me, many years ago, I was a public defender handling, representing people charged with crimes, and it was often the case where the facts and evidence against my client were pretty slam dunk, and of course the district attorney has the option whether to file and proceed with the charges or not. So if they are proceeding with the charges, then they feel it's a pretty good case. And so representing criminal defendants, I would get a case and there'd be like literally at first read no possible defense to this, but ultimately as I kept through the process, always find at least one thing or two things that I could argue with a straight face to a jury. And in a similar way, even in really strong cases or really strong defenses, I can always find a few things that I can argue with a straight face when I'm in either room.
Well, I guess with that kind of broad view that we've narrowed a little bit on some of the reasons or some of the values of the mediation process that a litigator might be thinking about in advance, let's talk a little bit about how they can go about accomplishing that objective or setting themselves up to accomplish that objective. And so, if the purpose, for example, is to allow the mediator to be evaluative, then that might be a mediator who you got to give everything to, right? I get a brief, it's 5 pages long. It gives me kind of some vague facts. And the way I do it is I read that immediately, and then I send out a list of questions and I set a pre-mediation call, because a lot of what I'm doing is, you vaguely mentioned this police report. Show me the police report. I'll read it. It might be mediators that won't, but you will. You, JJ, and I, we'll read it all. And maybe I won't read the whole deposition transcript, but send me the transcript along with some citations so I can look at it. So that if that's the purpose, meaning that's, I think, one of the biggest values for a litigator to try to focus on what their goal of the process is that if your goal is to let the mediator be evaluative, you got to make sure that you arm them with everything they need to do that. If your goal is for them to work on your client, then maybe it's prepping your client in advance to set them up for what the process will look like. I think it's important we listen to this third party. They're neutral. They have no skin in the game. That's the biggest value I think we need to take from this process is we get to, hear from a potential juror how they view our case. set the client up for that success in advance. And if you don't prep that way, but that is your goal, then you show up at the mediation, the client's not really prepped for it. Everything's kind of on the fly. So why don't we talk through some of those things, preparing briefs, client preparation, gathering evidence. We'll go through kind of one by one, but what are some of the most critical things that you think match some of those intents or values that the lawyers are looking for that they can do in advance of the mediation to accomplish that?
Yeah, well, I think the most important thing is the briefing and the timeliness of the briefing. I ask for the briefs 2 weeks ahead of time, and I'd say 95% of the time I don't get the brief 2 weeks ahead of time. But typically I'll get them, a week out or maybe a couple days out. And that's usually not a problem. The problem is getting it the night before or the morning of.
Right.
And to some extent, I know lawyers are busy. Some lawyers handle a whole lot of cases, and they've got to sort of be selective as to how they allot their time and so forth. And, there are some cases that I get to mediate where the facts are pretty straightforward and maybe case values are the primary area of dispute. And in those kind of cases, it may not be as critical. You should still get the briefing in, at least a couple days before. But a case of any complexity, sending a 30-page brief with 100 pages of exhibit the night before or the morning of is almost as bad as not submitting a brief at all. I mean, I'll give it a cursory read, but I'm not going to have time to delve into it. And there are cases, when I get cases that are really complicated, it takes, I spend a lot of time going through the briefing and researching anything I need to research in terms of the legal issues involved in the case. And I can't do any of that if I get the briefing the day before or the morning of. So it creates an obstacle in the process. It's not fatal to the process. I mean, in cases like that, I'll work through the process during the mediation and, look up things I need to look up during the mediation. But it's not a good way to start the process off. And it makes it more, it seems to me one of the primary things that attorney needs to do or try to do is, not only provide the mediator with as much information as possible to make sure he or she not only understands the issues, but has a favorable view of their side of the case. But to, kind of enlist the mediator as their ally early on. It's like, we want the mediator looking through the lens, our lens, not through the other side's lens. And so, for that, we're going to get him the brief early, so maybe he'll read ours first and we'll have a leg up in terms of how he's going to be looking at this, making the mediator your ally, helping the mediator help you. Mm-hmm. A lot of times that's really diminished by the fact that either the briefing's not sufficient or it's submitted tardy.
Right. Yeah, I think that's a great point. And I'm trying to think back to when I was a litigator and how I would prepare for the mediations. But what's kind of interesting to me about it, as you were talking about, I'm thinking about this, is that I don't know that most people, when they prepare for the mediation, are thinking about the case in the way that a mediator might think about it. And that really is, give me all the ammunition you have to use it with the other side. This is your chance to essentially try this case in a mini trial, if you will. And, it's so often that we'll get into the day of the mediation and I'll start talking to the plaintiff and they'll say, and this, my buddy was nearby and heard this exchange and heard the discriminatory comments. Oh, interesting. Was that person deposed? No. Do you have a witness statement from them? No. Well, do you expect them to testify? Well, we listed them as a witness, so we can call them to testify. Okay, great. But for today's purposes, can you get them on the phone? And I mean, sometimes now they're popping up onto the Zoom to share their experience. They're sending an email on the spot. They're sending a text message. And I mean, in the defense room, they don't know about this. And especially with the confidentiality of mediation, this is a perfect opportunity to use everything And so much of that ends up becoming a scramble. And it's like, this could be a pivotal question for today's mediation. And I think that would be something that I want to see more litigators do and think about purposefully in the preparation process. Is if your goal, part of your goal is obviously to get the best outcome, to get the most money on the plaintiff side and on the defense side to save the most money. Well, if you have stuff, it might be buried in mountains of documents. Being more careful and thoughtful in how you brief it and actually thinking about the briefing from a perspective of not just what do I want to tell the mediator, but what do I think it's helpful for the mediator to know to arm them to go to the other room and ask for more money or tell them why they need to take less money. How is that kind of piece played a role in your practice? Do you find some lawyers are better than it at others? Do you try to prep them in advance of the brief writing? That's a tough piece to do if you don't have multiple calls or convening calls to say, when you brief it, do X. How do you approach that?
Yeah, first of all, I do what you do in terms of reading the brief when I get it. If I have any questions, I'll contact the person that submitted the brief and ask them for answers to that, or if exhibits that I want to look at that haven't been provided and so forth. It's not my practice to do pre-mediation calls. When I first started out, I did that, and I found out that most of the time it was sort of a waste of time. It kind of turned into kind of a pro forma thing. I found that if there are cases where attorneys feel they need a pre-mediation talk, then they'll contact me and say, hey, can you call me before the mediation? Then I'll do that. But in terms of preparing for the mediation, I mean, one of the things that fascinates me about running into situations where that doesn't happen is that mediation is so expensive now. I mean, it's not cheap to hire a mediator. If you're willing to shell out the money to do that, it seems to me that in and of itself should be enough to kind of prompt you to try to get as much value out of the process as you can. And in order to do that, it's pretty obvious that the more you put into the process, the more you're going to get out of it. And as you said a few minutes ago about providing ammunition, I mean, that's a significant portion of my day as a mediator, saying, look, give me ammunition to take over there. I mean, they're saying this about that. I want to present your case or your defense as strongly as possible. I need you to give me as much detail and information as you can so that I can use that and that can alter what their expectations are here today. And so, usually I get some of that, maybe a lot of that ammunition in the briefing ahead of time, but fairly frequently a lot of it comes up during the process. It's not unusual for there to be unanticipated arguments that come up, and they need to maybe do some research while the mediation's going on because they didn't expect that argument to come up. It's kind of hit or miss. Some attorneys I find come super prepared, and I think the day tends to go better for them. Yeah. Some attorneys kind of like, give me a skeletal brief, even if it's a complex case, and then they attempt to put the meat on the bones during the mediation process itself, which can work, but it makes the process more difficult and more time consuming as well. So.
Yeah, which I think is a great kind of segue into whether or not parties should share briefs. And I know different mediators have different perspectives on it. I personally think that it has to just be one piece of that thought process when you're preparing for a mediation. What is my value here? Because if some of your value is to persuade the other side, you don't feel like they fully have a picture of your case and really see it the same way, or see it the risks that might exist. You might want to prepare a brief that pulls the punches a little bit, that's not so aggressive or oppositional, but that is very clearly going to lay out your position, very clearly kind of lay out what your trial brief might look like, so to speak. Whereas if kind of both sides know everything, everyone's smart lawyers, we have a good view, I get it, I know those are your risks, and then your brief might not be for the purpose of educating the other side, or it might be more to tell the mediator the dynamics you have with clients or whatever it might be. So I think about it as the question of whether or not you should share a brief has somewhat to do with what your objective of the mediation process is, and that it's not always, it's not a one size fits all. Sometimes you should, sometimes you shouldn't. What's your experience? Do you encourage the parties to share briefs in advance of the mediation?
Well, I mean, I don't encourage it in the sense that when we do a case intake, I don't advise them. By the way, I think you should share your briefing, because I think that's a decision that the attorneys are competent to figure out on their own. Although, when I do mediate, I do make if the situation arises where, gee, should I have shared the brief or not? I will give my opinion, which is, yeah, I think it always, or most of the time, it works to your advantage if you do that. And this comes up on cases where one side shares it and the other side doesn't. And, then you get, well, I shared my brief, why didn't they share theirs? And
Right.
so forth.
Sure.
And the other part of it too is that 90% of the time, at a mediation, I'll go through the briefing on one side, I'll get it confidential, do not disclose to the other side. So then I'll go through their briefing at the beginning part of the mediation, and then I'll say, hey, is there anything that is confidential you don't want me to mention to the other side? And again, 90-some% of the time, they'll say, no, go ahead. There's nothing confidential here.
They just mark it that way at the top for fun,
Yeah, I think what it is I think some attorneys think if I give them advance notice of my argument, that'll give them more time to prepare for those arguments at the mediation. They'll allow them to do more research, whereas if they don't get it in advance, maybe they won't have time to research, and maybe that'll give me an advantage somehow. So that's a dynamic involved. From the plaintiff's side, I think, and this segues too into whether a demand should be given before the mediation or not. Yeah. I think what I've seen some plaintiffs' lawyers do is they'll send a redacted brief over to the other side, where they'll redact everything but leave in their damages calculation and their demand. And that serves two functions. I mean, one is a lot of times it's a good thing to get the demand out a couple of days before the mediation. And, for a bunch of reasons we can get into. And
insurance carriers need briefing, or, the business needs to socialize to the realities, a whole bunch of good reasons.
Yeah. The anchoring and all that, but including the damages calculations. I mean, that's something there's really no reason to keep confidential in the first place. And I think it does help the defense, because they can sort of at least see what the argument is as to why the case should add up to what the demand amount is. And of course, everybody knows the demand amount's much higher than what the end of the day number that a plaintiff would accept, but at least it puts kind of a context early on as to whether, for example, there's any disputes over what the wage loss totals, or how long they've been out of work, whether they've mitigated their damages and not if it's a termination case, and that kind of thing. In general sense, I can't remember any cases where someone submitted their entire brief to the other side in advance and regretted it later.
And especially in, wage and hour class actions or PAGA or whatever it is. And I know that's something you feel strongly about, sharing it in a spreadsheet and making sure everyone knows what the calculations are. And sometimes it's a minor just miscommunication or misapplication of something that can be clarified. And you get, like, I had a case recently I mediated where there was a termination, and they viewed it as a layoff because of seniority. And it was just, we fired the person who was the last to be hired. And there was a dispute about that. And then it's just, all we need is the actual payroll records to show when the person who was kept was hired and when the person who was fired. Produce that. And it's shocking to me as the mediator, why has that not already been produced? But, the plaintiff's asking for everything in discovery. Defendants giving it, they're not presenting their cases, so to speak. And so they're not necessarily thinking about it from that perspective. But I think that the more the litigators do that, I remember one of my very first mediations where I felt great about myself as a litigator, as the representative for the parties, was when one mediator who I respect a lot, and I mediated 100 cases with as a litigator, she had me in a room with the lawyers for the other side, and we sat down and kind of went back and forth in a collegial way, and she controlled the process, just kind of sharing opening statements to a jury. What it is, how do I string together all the evidence? How do I present it in a way that the jury's going to understand it? And then we split off, and she may have just been kind of blowing smoke and hyping me up. But she said, Abe, the way that you just strung together all of that evidence, the way that you presented it in that cohesive way to the other side, totally changed the tenor of this conversation, because until now they're seeing it as chopped up little bits of pieces, and they've got a response to that one and a response to this one. This is the first time they're hearing it strung together in a cohesive way of what a jury would hear. And so I think this is a great opportunity in a mediation to do that. And whether you're doing that in an executive session with the lawyers together, which is something I strongly believe in, and Gig Kariaka, we did a whole episode with about that. But whether you're doing it that way or the mediator is the one who you're doing it through as the conduit, I think that it's a great opportunity. And so, yeah, share as much of it as you can. Share the damages calculation. Explain to them why, because sometimes it's like, well, hang on a second. You're aggregating all the 6 violations you claim, but we have clear payroll records to show no meal break or rest break. So there might be 3 or 4 others, but those 2 can't be in your calculation. And it could be a simple, just reconciliation of that gets the ball rolling. So I 100% agree. And I don't know if there's anything else about anything I just said that you think's more worth noting.
Well, no, it's just what you just explained about your experience, I think underscores what we've been talking about the importance of preparation ahead of the mediation. Obviously, you thoroughly prepared and had that all together ahead of time, so that when it came time to do that in that executive session with the other attorney, you were able to do that cogently, and I think probably ended up with a better result than if you hadn't bothered to put that together before the mediation.
Yeah.
So,
oh, fair enough. Well, that's a good point to kind of, I think, shift into maybe the hot topic of it, which is what are some of the things that we see that lawyers do when they're probably not being thoughtful about the goals and the values of the mediation process? And just to kind of list some off in broad spectrum, and then we'll get more narrow: not having the decision makers present, or sending a junior associate who can't make any moves themselves. They have to call the partner, surprising the parties with evidence that they didn't know about. Some of those are things that I think, again, if the whole kind of topic of today is being thoughtful about the goals of mediation, the purpose of mediation, and then structuring everything you do to that end, those are some of the things that I think hinder the process, that if the lawyers were really thinking about how the mediation is going to go, about how I can utilize this mediator most effectively, we might not see. So why don't we talk a little bit about that, and maybe more than anything, the advice we can offer to litigators coming into the mediation process, making sure the right people are there and all that. What are your general thoughts?
Yeah, I mean, I think, just starting off about, decision makers being present, it's hard to underestimate the importance of that. And I think some attorneys, when they view the mediation process, they think, well, they don't really need to have their decision maker there, because they can report during breaks in the process, they can report to the decision maker and let them know what's going on. And then this comes up with the defense if the insurance adjuster isn't participating accurately, or on the plaintiff's side, so if the plaintiff's attorney decides not to have their client present, usually that's a bad thing. Not always. I mean, some cases, for example, where a plaintiff's attorney is representing a really unsophisticated client and basically is in 100% control over the decision making, it's not a problem in terms of impacting the negotiations. Where it becomes a problem is when the defense finds out that the plaintiff isn't personally present and then blows a gasket because they're not taking this process seriously. And then on the other side, with the insurance adjuster not being present. And the problem with that is mediation's a really personal process. The mediator, has to do a lot of things, has to, interact directly with the participants, establish a rapport, which is necessary in order to establish enough trust that the mediator can get buy-in from each side in terms of different parts of the process, as the mediation unfolds. And there's also a real persuasion element. Good mediators, I think, need to be really persuasive, and that comes as part of presenting each side's case as powerfully as possible. And that persuasion element really only works in a one-on-one interaction in person. So if you're doing that, at the mediation with an attorney, let's say, and then they have to call the adjuster afterwards and kind of fill them in secondhand, then, unless that attorney has a lot of control over what the adjuster is going to do, or the adjuster really trusts the defense attorney, then that can create a real problem. In those cases, I think, the difference is that, both sides come into the mediation thinking about the case one way, and in a typical mediation, that changes as part of the process. If you're not participating in person, it's far less likely that change of perception is going to happen, because you're not going to be listening to what the mediator's saying directly and so forth. And and that kind of dovetails into the other aspect of this, where the parties show up, but maybe not the right parties. I see this happen on the plaintiff side, where a junior associate shows up to mediate the case, and the partner, the supervising partner, is not present. And then all that stuff I was just talking about in terms of the need for a one-on-one interaction is missed by the supervising partner. And it can lead to really weird results. I can remember one case in particular where a junior associate showed up, and he was communicating with his supervising partner who was out of the country, and they were communicating by phone and lost the connection, and he was unable to get that connection back, and for that reason was unable to make a move. Wow. And so that for that reason, we had to end the mediation session, because the junior associate didn't have authority to make another move. And that resulted in a second mediation session having to be scheduled, where that partner showed up for the mediation, and we got the case resolved. But it made it more difficult, because the other side was obviously very frustrated and upset. And then there's the added expense and the added issue of lost momentum. They have to start from scratch at the second session. And so it's really important to have the right people there, and it's really important to have the decision makers there in most cases. Class action cases, not having a plaintiff there, that's more common. Makes sense. I think a lot of times to just have the plaintiff, the class members on call. And I see that happen fairly frequently in mediating class or pocket cases. But wrongful termination cases, it's important to have your client present, I think.
Yeah. And one interesting thing about what you just described that I think is so critical is sometimes you'll even have a mid-level, I don't want to say junior, but a mid-level associate who does have authority, who is entrusted to mediate this case, but they have to kind of talk about the ranges with a partner in advance or something like that. And when I was running a firm, so I was the managing partner for the firm for a while, before any associate ever went to mediation, we would sit down and round table the case. And we would usually do it once a week for a dozen cases at a time. But we would round table, tell me the facts, pretend, play devil's advocate for a second, and tell me the defendant's strongest arguments in response, tell me the damages. And then I would be able to say as the partner, okay, this is what I would like you to try to get, and let's see if we can get that. This is what I assess it. And then I would trust that associate to go in and get it. And within some range, be able to say, okay, they could settle it for a little less. Obviously, you could settle it for a little more, if you're on the plaintiff side, or vice versa, if you're on the defense. But then material changes would come up all the time. And I was, I had roundtable it the week before, so I still remembered, and the associate would call and be able to say, hey, look, they just produced this witness statement that's really bad for us. I think we need to adjust downward. Yeah, sure, fair enough. I agree with you. Go settle it. And there are, I think, a lot of lawyers that aren't doing that process in advance. And so sometimes you even get the partner showing up with the associate, but they haven't roundtabled it. They're looking at it from, the day of the mediation. The associate wrote the brief, maybe you even got it a week before, but the partner hasn't looked at it. And now things are evolving. And I think that doing more of that prep on the front end, knowing that that's the value of mediation is critical. But at the same time, obviously, if that partner has to do that assessment and they haven't done it in advance and they're not there, they're by phone or something, so they're not hearing the witness statement. They're not hearing that lawyer string together the facts in that executive session. They're not going to get the full view, the whole gestalt of it, if you will, to be able to say, okay, yes, I agree, we should reduce this value. So even if you have access to that partner, even if you can get them on the phone and they can say, or that adjuster, you get them on the phone and they can say, sure, here's some more money, but do they really appreciate why you need that much more money? They weren't there for all those arguments. They don't get that personal element. So I completely agree. I think it's so critical to have everyone in the room as much as possible. And with Zoom, it's a great feature. It's one of the things I actually love about it is adjusters all over the country can now be on it. Business owners, decision makers can be on it. So I think that being purposeful about it in advance and then also during the process, making sure that the right people are there to actually assess that ongoing, ever-changing target that comes with the mediation process is critical. So, I completely agree with everything you said.
What I've seen in my practice is most attorneys are professional. Most of them have prepared their clients. Most of them get you the brief sooner than a day or two before the mediation. But there are a few, every once in a blue moon, you get a situation where that doesn't happen. That just kind of underscores just how damaging it can be if you don't
take it seriously. Yeah, and I think that's exactly right. And I agree. Most of the clients I work with are very well prepared. And yeah, you're right. Some are better at the brief writing than others, or some may put more thought into it. But more than anything, I think it's the value to the clients, the value to the listeners and the viewers of the podcast is you're all professionals. You know what you're doing. You're coming into the mediation process. The more that you can do this is really about what you said earlier, JJ, which is to help us help you. The more that you can arm us with as the mediators, the more information we have going into the process and right away in the process to help us understand the value we can provide and to help us get to that outcome, the better. And so I actually think that everything we've talked about and everything you've shared about your experience is invaluable to the listeners and the viewers in terms of just understanding how they can best be thoughtful about going into the mediation process and then how they can track that intention with the actual actions that they take in preparation for and during the mediation. So I really appreciate you being here and giving us so much of your time. I don't want to keep you too long. I'll ask you the final question I like to ask every guest, which is, what is it about mediation that you love? What keeps you going day after day to keep doing this? Obviously, other than the paycheck.
Yeah, I mean, for me, it's, and I know there's a disagreement, I think, between mediators as to whether, your goal should be settlement or your goal should be to have a good process. And I've heard both sides of that. I've heard other mediators say, oh, I don't care if this case settles or not. It's just important to have a good process. I don't fall into that camp. I think you're hired to get a settlement in the case. And, that doesn't mean you're going to get a settlement in every case. That doesn't mean that no matter what you do, how hard you work, that you're always going to get to, a settlement, because so much of it's in control of the parties. And all you can do at the end of the day is try to guide them to a settlement. But what keeps me going is that effort to get a settlement, knowing that that's a good day when you get a settlement, because the parties have, whether they're super happy with the settlement or think they can live with the settlement, but just the idea of putting the case to rest, getting that certainty makes it, for me, kind of an example of doing God's work. And I feel very, very proud of and humbled by being in a position where I'm allowed to do this work. And before I go, I wanted to also thank you for having this conversation with me today. I found it very enjoyable and very informative. Even though you've tried to keep the focus on me, I think that a lot of the valuable insights from today's session came from you and your experiences. And you're obviously a very talented, I'll say young mediator, because by comparison,
I'll take it.
You're young. But anyway, I really enjoyed today, and I thank you for allowing me an opportunity to share my thoughts.
I really appreciate that. And as long as you finish that with mediator, I'm happy to be called young. As long as I'm recognized as a mediator, that's all I need. But no, I really appreciate it, and I appreciate their recognition. It really is a conversation more than anything, and it's one of the things that I think provides some value to the listeners and the viewers also, that this isn't lecture style, this is more of a conversation. But I really appreciate you taking the time, and hopefully we'll get to do it again sometime soon. So thank you so much, JJ. Really appreciate it.
Very welcome.
Without an audience, we would be nothing. So I'd like to thank you, the listener, for tuning in to another episode of Mediator in the Middle. Please take the time to subscribe on your favorite podcast platform, Spotify, Apple, whatever it might be. And please feel free to refer a friend. Until next time, we look forward to seeing you, and keep calm and mediate on.